Nisha, what is the importance of fiduciary relationship between a client and a solicitor?
Thank you for the question, Professor. The first element to be discussed is fiduciary relationship on duty of care. There is fiduciary relationship between the solicitor and its client. This shows that a solicitor owes duty towards their client in handling their cases. A lawyer must act in good faith to advance their client's best interests, while lawyers has a duty of confidentiality towards their clients. Lawyers also has the duty to not act or continue to act where there is a conflict of interest. By maintaining a good fiduciary relationship with clients, the relationship between both the lawyer and the client will be strong. The case can be settled smoothly and the conflict can be avoided.
Can you now compare it with UK common law cases and our Malaysian position?
So the comparison can be done between the English case Lampier and Pipos and Malaysian case Nyonya A and Kevin Satyasilan and another. Basically, in the case of Lampier and Pipos, the court defined duty of care by a lawyer towards the client, which is to undertake to bring fair, reasonable and competent degree of skill. We can see that a lawyer has a duty of care where they need to practice a reasonable level of professional skill when they are dealing with their client's case. While in the Malaysian case of Nyonya A and Kevin Satyasilan and another, there was a failure from the defendants to advise their client on the failure in the payment of the amount within the given time, which will render the suit to be struck off. The court further stated that the law firm must have at least issued correspondence to the plaintiff in regards to the important matter. Here we can see that the lawyer owed duty of care towards the client to inform them about every important details in regards to the case. Since lawyers have a special relationship with their client and their failure to do so will render them to be liable for professional negligence. As we can see from the comparison of both cases, for the first element, both common law and Malaysian position holds a similar view in regards to the duty of care.
What is the effect when a solicitor has breached his duty of care? Can you help me compare it with the UK common law position alongside with the Malaysian position?
Thank you for the question, Professor. For breach of duty of care, the test is whether they did a poor job by comparing what a reasonably competent professional in their position would have done. Therefore, lawyers must always be careful in exercising their duty or professional skill towards their client. The failure of a solicitor to exercise their duty of care towards their client will make them liable for professional negligence. For English position, we can look into the case of Barrett and Ansell. In this case, the barrister act of negligently advised Mr. Barrett to settle his divorced wife's claim for a share of matrimonial home on disadvantageous terms does not hold him to be sued, as a barrister enjoys immunity from being sued for negligence. So, under English position, a barrister enjoys immunity from being sued.
Prof, may I illustrate a Malaysian case for the second element?
Joyce, of course, carry on.
Thank you, Prof, for allowing me to do so. Okay, Prof, I'll give a Malaysian case to discuss on the Malaysian position for the second element. The Malaysian case that will be provided by me is the case of Mulfa Kluang Maritime Carriers Sdn Berhad and Philip Koh Tong Ngee and others. It's a 2016 MLJ case. So, in this case, end of the sale and purchase agreement, the plaintiff discovered that portion of both the lots had been surrendered by vendor to the state authority in 1988, and in fact plaintiff had ended up paying for whole portion of two lots while owning a lesser area than agreed. It was held that defendants have duty to notify and advise the plaintiff. The major issue in this case is whether lawyers are liable for professional negligence because they did not inform the plaintiff on portion that has been surrendered to state authority. Here we can see the lawyers have a duty to inform clients on every important detail. The lawyer in this case had failed to inform about the portion of both the lots that has been surrendered by vendor to state authority to their clients. The plaintiff, which renders to breach of duty of care here. A duty of a solicitor is to make sure that all necessary documents in regards to transaction of a land must be properly prepared to carry out a thorough inquiry and to make sure all the details which are stated in the transaction documents is correct. So Professor, to conclude the second element for negligence, the major difference between the English position and Malaysian position is that English position is that UK has immunity in regards to professional negligence, whereas for Malaysia, the advocates and solicitors are not immune, and thus they can be liable if they breach their duty towards their client. For instance, the solicitor did not attend the court hearing and the case was struck out, so he can be sued for negligence by his client. This is for Malaysia.
Joyce, what would then be the consequences of professional negligence?
Thank you very much for the question put forth, Professor. So in answering to this question, we can look at the third element that constitutes negligence, which is breach have caused loss. Under this, wrong opinion too can lead a client to suffer loss, which leads to a certain damages to be claimed. To be noted, Professor, causation is the key element you need to be able to establish if you are to win a compensation from the advocate and solicitor in a professional negligence suit. In simple terms, this is proving that the negligence which has occurred has caused the loss that is being claimed.
Alright, good try, Joyce. Can you now illustrate it with the English common law position alongside with the Malaysian position?
Sure thing, Prof. I'll illustrate them. Giving a case for English position, which is the case of Bolam and Fryan Hospital Management Committee, 1957, wherein in this case the plaintiff bore the burden of proving that the defendants negligently performed or omitted to perform their duty, and such negligence or omission was the effective cause of injury or damage to the plaintiff. The test to determine causation is the but-for test, i.e., would the damage of which the claimant complains have occurred but for the negligence or other wrongdoing of the defendant. A case to illustrate for Malaysian position would be the case of Syarikat Xiao Tech Hau Realty and Developments SB at Malik and Joseph Au, sued as a firm, which is a 1999 case. In this case, we can see the plaintiff claims damages for the professional negligence against the defendant who failed to appear at the hearing of an appeal by the plaintiff, resulting to the appeal being struck out. The held in this case was referred to Rule 6, 15 and 24 of the Legal Profession Practice and Ethic 1978, wherein failure to attend the hearing is non-compliance of the rules and a total disrespect to the court. The Federal Court held the overall conduct of the defendant in the management of the case fell short of that of a prudent and reasonable lawyer. He must therefore be liable to the plaintiff. In a nutshell, Professor, the third element to constitute negligence is basically the client here has suffered a loss due to the act of the solicitor in negligence of torts and can claim damages.
Can you tell me if a lawyer can claim for immunity in Malaysia and also compare it with UK common law position?
To answer that question, in Malaysia, an advocate and solicitor may be sued for professional negligence. They do not share the same immunity as provided by the common law. According to the English law, persons taking part in legal proceedings, such as the judge, the advocates, including the barristers and solicitors representing their clients, the witnesses, and the parties themselves cannot be sued for anything written or spoken in the course of the proceeding. In the Rondell and Worsley case, any lawyer, be it a barrister or solicitor, appearing on behalf of the client in court is an office of justice, just like the judge. Hence, public policy requires that he be protected from legal action brought by unhappy litigation. An advocate should remain immune from negligence in respect of his actions in court. In the case of Taylor and Serious Fraud Office, the immunity policy is to enable people to speak freely without fear of being sued, whether successfully or not. However, it is still accompanied with an exception in the form of malicious prosecution. If a defendant is convicted after a full and fair trial, the remedy is to appeal. An attempt to challenge the convictions by suing the defense advocate would be an abuse of process, as per the case of Hunter and Chief Constable of the West Midlands Police. The English position of providing immunity are based on the grounds of, instead of always thinking about the best to help clients and the administration of justice, advocates should start thinking about how to protect themselves from allegations of negligence from disgruntled clients. Real litigation is if a lawyer could be sued for negligence, it would mean a new trial of the original case. If actions were allowed, it would open the door for every disgruntled client, leading to dozens of similar cases. Any convicted persons who blame his counsel could immediately file negligent action. Instead of opening the door for him, the common law position would bolt it. This is all highlighted in the case of Rondell and Worsley. Negligence in law can be defined as a failure to take reasonable care in order to avoid causing injury or loss to another person. Similarly, professional negligence means the lawyers are expected to conform to the standards that are termed as reasonable competent practitioner. Therefore, a breach occurs if a lawyer has fallen below the standards normally adopted by lawyers. The conduct and ethics of advocates and solicitors in Malaysia pertaining to the duty towards the client are regulated by written rules, which include the Legal Profession Act 1976, the Legal Profession Practice and Ethics Rules 1978, the Solicitors Accounts Rules 1990, and the Bar Council rulings. Failure to comply with these rules amounts to misconduct and would likely cause an advocate and solicitor to be liable for a disciplinary proceeding. The provision in Section 117 Sub 4 of the Legal Profession Act 1976 declares a provision in an agreement that states that the advocates and solicitors should not be liable for negligence or shall be relieved from any responsibility shall be wholly void. This clearly indicates that advocates and solicitors are not immune from being sued by the clients for misconduct or negligence committed. In the case of Sulaiman, Ente and Borneo Synergy, Sdn Bhd, it was established that in Malaysia, an advocate is not immune from negligence suit. The Malaysian position always differed from English law, as advocates here have never enjoyed immunity from suit of negligence. To sum up, a lawyer can never guarantee a particular outcome, and not getting the desired outcome in your case is not enough to amount to professional negligence. Nevertheless, as in the case with every regulated profession, a lawyer is bound by prescribed standards, codes of ethical conduct, and a high degree of professional care. If a lawyer has acted inappropriately with the intent to harm the client, that client may lodge a complaint against the lawyer to the Malaysian Advocates and Solicitors Disciplinary Board. Any advocate and solicitor who had been guilty of any misconduct under the Legal Profession Act 1976 shall be liable to one or more of the following penalties or punishments, such as to be struck off the roll of advocates and solicitors, to be suspended from practice, or to be ordered to pay a fine or to be reprimanded. That is all from me. Thank you.